in person with her client, Bradley Belial Oyat. We have Emma Hanu in person with her client, Dominique Fleckner. We're set today in these matters for preliminary hearings. Are they proceeding as such?
Yes. Yes, Your Honor.
All right. Mr. Vila, this is a joint hearing because these are co-defendants. So please call your first witness.
State calls Captain Julie Mead.
Captain Mead, please come forward, raise your right hand, and be sworn in.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I do. You may begin.
Could you please state and spell your name?
Julie Mead, M-E-A-D,
And how are you currently employed?
Captain for the Burnett County Sheriff's Office,
And how long have you been so employed?
25 years.
Prior to today's hearing, did you review criminal complaints as they relate to Burnett County cases 25 CF 150 and 25 CF 151 in the matters relating to Dominique Fleckner and Bradley Belial?
I did.
Did law enforcement execute a search warrant at a residence at 648 Nelson
Your Honor, I'm going to
Street?
object to her testimony. If the only knowledge she has is that she read criminal complaints, that doesn't satisfy the personal knowledge requirement. Hearsay is allowed, but that doesn't mean all the other rules of evidence go out the window at a preliminary hearing.
Hearsay is allowed. You can object if there's hearsay upon hearsay. But in order for her to, she's allowed to testify as to what she reads and provide hearsay. She doesn't necessarily need personal knowledge. Objection noted, but overruled.
Did law enforcement execute a search warrant at that residence at 648 Nelson Street North in the village of Grantsburg?
They did.
Is that area located in Burnett County?
Yes.
Did law enforcement make contact with anyone at the residence?
Yes, they made contact with Bradley Belial.
And how was Mr. Belial identified?
Personal knowledge of the officers that was there.
And did you review any booking photos of Mr. Belial prior to today's hearing?
I did.
Could you please ID Mr. Belial by where he's sitting and what he's wearing?
Yep, he's sitting next to Miss Landgraf at the defense table, wearing a jacket.
Let the record reflect that Captain Mead has identified Mr. Belial, otherwise known as Oyat. Mr. Vila,
Yes,
I'm going
Your
to ask you kindly to slow down.
Yes, thank you, Judge. Does anyone else reside at the residence?
Yes.
Who resides there?
Dominique Fleckner, and then the residence owner, Rita Wenzel, periodically.
Did law enforcement make contact with Ms. Fleckner?
They did. They actually made contact with her prior to the execution of the warrant.
And how was she identified?
Prior law enforcement knowledge.
And prior to today's hearing, did you review any booking photos for Ms. Fleckner?
I did.
Could you please ID Ms. Fleckner by where she's sitting and what she's wearing?
Yes, Ms. Fleckner is sitting at the defense table, also wearing a jacket, black jacket.
The record reflect that Captain Mead has identified Ms. Fleckner.
Was the house at 648 Nelson Street searched?
Yes, it was.
What was found?
In the living room, officers located a purse containing Ms. Fleckner's driver's license and other identification cards, health insurance information for kids. Inside that purse was also a baggie, field tested positive for marijuana, weighed at 1.14 grams, and a, a metal smoking device that also field tested positive for marijuana. In one of the bedrooms, later identified by the kids as Dad's bedroom, a baggie of crystalline substance was located. That was also later field tested positive for methamphetamines.
Does Ms. Fleckner have any prior convictions for possession of THC?
Yes.
And what county was it in?
I'm not sure. I believe it was Burnett.
I
believe that would be outside the scope of her knowledge.
Yeah, I believe so. No further questions, Your Honor.
All right, thank you. Ms. Landgraf?
Did you take part of this in the search?
I did not.
Do you know anything about this incident other than what you've read in the criminal complaint?
No.
No questions.
All right, Ms. Hanu?
I apologize. Everything glitch. If you can't hear me or understand me, let me know. Sometimes I mumble a little bit, and I like to tell people before that. Based on your review of the reports, Ms. Fleckner was not at the residence at the time the search warrant was served.
Correct.
And at the time that law enforcement made contact with her, they did not perform a search of her.
Correct.
And later, law enforcement interviewed both of Ms. Fleckner's children.
Correct.
Neither of those children identified the methamphetamine as being Ms. Fleckner's.
For the record, how old are the children?
I don't know. They're 7 and 10, Your Honor.
Thank you.
I don't believe so.
I have no further questions, Your Honor.
All right, redirect.
Ms. Fleckner does reside at the residence, correct?
Correct.
No further questions, Your Honor.
All right, additional questions from either counsel? Okay, you may step down. Thank you. Any arguments from defense?
Not for today's purposes.
No, Your Honor, just one note of correction. I don't believe Rita Wenzel lives at the residence.
Okay. For a bind over, I don't think that is relevant or necessary. However, thank you for the update. Based upon the testimony of Captain Meade, the court will find that felony was probably committed by the defendants in this matter. The court must look at the evidence in the light most favorable to the state. So I do find the probable cause and bind the matters over informations.
Thank you, Your Honor. I'm going through and filing the informations for both cases. Right now, they will mirror the criminal complaint in both instances.
Proceed with arraignments today or set for another day.
Can we just have a second?
You may.
So we can go ahead and enter those not guilty pleas on the case study. And then we can set their status hearing. And it's pretty sure it's probably not gonna be really good. So we just take care of that section. And then, wait, we have Mr. Secretary to judge just find me.
Excuse me.
We're ready to proceed with arraignment.
They mirror the criminal complaints. Ms. Landgraf, does Mr. Belial yet understand the allegations and the maximum penalties?
He does. We'd waive a formal reading, enter not guilty pleas to all counts.
Not guilty pleas will be entered on your behalf on all counts. Ms. Hanu, as to Ms. Fleckner?
Yes, Your Honor, she's aware of the maximum possible penalties of both charges. We would waive formal reading and enter not guilty.
Not guilty pleas will be entered on her behalf. She is entitled to a jury trial, would be entitled to a speedy trial should she request one. Has an offer already been presented prelim?
Yes, for both co-defendants, offers were communicated, but an updated offer does need to be communicated to Attorney Landgraf or Mr. Belial.
Updated offer.
The updated offer, it's going to kind of depend on what kind of treatment he's willing to do so that we can enter in those negotiations. I just need to schedule a phone call with her so we can hash out those details.
Okay, so it depends on whether or not he wishes to engage in treatment
Correct, Your Honor.
and what type.
Some kind of AODA, some kind of,
It was a question.
oh,
And what type, question mark?
yes, it's going to be AODA and follow through, or if he does some kind of inpatient treatment regarding to potential drug abuse issues, I'd be willing to do something substantially different than what I offered.
All right. And there's another open matter, confidential matter. Did you take that into account?
Yes, that's why I received new information from the department. That's part of the reason why I'm updating these offers.
Excellent. All right. Thank you. We can get a status conference set. Um, I don't have a time. I'm gonna try and set it on our permanency plan date, but I don't have a time. We're coming back. Holy cow, it's way out there. March 30th. And I could do anytime between 9 and 10. Oh, actually, or I could do after that too. I could do 10:45 and on.
Your Honor, I'm sorry, I missed the date.
March 30th.
That works for me.
Okay. So does March 30th at 10:45 work?
Yep.
Okay, thank you. March 30th at 10:45. We will see you then. We are adjourned. We will go on the record in the matter 25 TR 775, 25 TR 1015, State of Wisconsin versus Mark Chanel. The state appears through District Attorney Kevin Schmidt in person. We have Mark Chanel appearing in person. We're set today in this matter for a status conference. All right, I was just looking, there are other cross-referenced things. I was just pulling up. And we have 26 TR 378, the refusal for the test. All right. So the court will also call 26 TR 378. County of Burnett versus Mark Chanel. Mr. Chanel is in person, the state through District Attorney Kevin Schmidt. So a status conference, Mr. Chanel, you were provided an ability to speak with one of our top OWI attorneys here in this area, and as I said, probably the state as well. And he graciously agreed to do that and to give you some information. So where are we with this matter? And I know, Mr. Schmidt, this is not your case, but you should have some notes or have an idea of where Mr. Belay is going with the matter. So Mr. Chanel, update the court.
Your Honor, in an earlier hearing, the state represented on the record that they were not pursuing refusal charges, right? Or I can get the transcripts, but
I believe that they said they won't if an agreement is reached and they'll deem the refusal reasonable. If I'm recalling correctly.
oh, well, I can get the transcripts. I don't believe that. I think it was different. They now added that charge approximately over 8 months after the arrest. This late addition creates unfair surprise and prejudice to my defense. I respectfully move to dismiss the refusal charge.
Mr. Smith.
The citations for those get processed in that manner. It's not even a charge. It's an administrative hearing that results in revocation of the license.
And there's a statute of limitations which allows, even if, let's say you commit a burglary a year or 2 years ago, there's a thing called statute of limitations, which would allow them to still file 2 years later for certain things. And this is a refusal. And so with the refusal, there's an ability, there's a length of time that they can file additional citations or forfeitures such as this refusal. And so I don't have any indication that this was done outside of the time limits. And I do believe, I recall that, and again, it's just what I recall. If you're going to order a transcript, that's great. And then you can let me know exactly what was said at the time. But I recall Mr. Valet stating that they could file a refusal, but they won't file the refusal. They will deem it reasonable if an agreement is reached. Some words along that line. But I can't give you the exact words because I don't recall exactly word
Yes,
for
I'm
word
here,
what
not
happened.
exact, but yes.
So that's denied, at least at this time. If you find out something else, you can renew your request.
Thank you. And then can I file updated motions right now?
What
So-
motions are you trying to file or would like to file?
Updated for the stop more pronounced and the refusal of a second blood test and other things.
We've already addressed those. They've already been denied.
There's more evidence I found on the videos I got last time.
So you're asking for reconsideration of the court with its decision?
Yes, for reconsideration for the new updated information I got from the videos I got last time I was in court.
Okay, that's one reason the court can allow an additional filing for a motion for reconsideration because additional evidence or facts were discovered. And they could not have been discovered at the time of the motion that was filed. So you would be able to file that. I can't make any ruling or decision on that right now because A, I don't have them to read and review, and B, there's something called notice that has to be provided,
Yeah.
and the state needs to be provided at least 5 business
Yeah.
days notice.
Yeah,
Okay?
I'm asking, can I submit them right now?
What you would need to do, yes, you can
Or-
bring them up to Amy, our clerk,
Right.
and she can take them and she will make deed to the
That
final
wraps up
pretrial
today's
on
hearing,
July 23rd.
but this case is far from over. The judge
Yes,
found there was enough probable cause for the
I
case
still
to
have a
move
few things
forward.
to get
Not
to
that the
file
defendants
these,
are
but
guilty,
yes.
but that the
Wait,
evidence is
what?
sufficient
You
for the
have
next
to
stage
file-
of the legal
to get
process.
the transcript.
Now the focus shifts to plea negotiations,
Here's the deal.
future motions,
I'm gonna tell you,
and whether the
we don't have
prosecution
much
can
time
ultimately
to
prove its
file
case
or
beyond
to
a
find
reasonable
a
doubt.
date for a
As more
hearing on
evidence
this.
and courtroom arguments unfold, the stakes will only get
But I just
higher.
wanna
What do you
let
think?
know you have
Does
to
the
give
evidence
court
presented so
reporter,
far seem convincing?
written
Or
notice
do you
that you're
believe the
requesting a
defense
transcript,
still has
and then
strong
she'll have to
arguments
make the
to challenge the
assessment and
prosecution?
Tell you how much sure that they are filed.
Thank you.
Okay, so you bring it right now.
We don't
Got a
need one.
copy
We're
for
in need
him?
filer.
You don't need to give him a copy because if you file something, that means it goes into our electronic system. And if you're an electronic filer, you would get automatically the notice saying this has been filed and you can pull up the document. He will get the ability to get that right as soon as she files it. It'll go into the electronic file and it'll be sent right to him. But I appreciate you trying to give him a copy today.
Okay.
This one is defendant's motion to dismiss refusal charge.
That one was done on the record, so you can't file that one because we just heard that one. Again, if you get additional information, if you order the transcript and something's completely different than what I had recalled, or something else that you noticed that would help support that from the transcript, then you can file, again, it would be a motion for reconsideration.
Okay.
Okay? And I'm not giving you legal advice, I'm just telling what the
Right.
law is in the process, okay?
Thank you.
So what else? What else?
What else for what?
I guess, is that the status? There's nothing else going on in the case. You've had no further discussion with the assistant district attorney that this matter is